call the Commissioners meeting of September 7th to order. First on the agenda would be public input. Anybody? Yes, Mr. Albee?
I had the YouTube available to me through GovernmentOversite.com, so I got to watch last week's meeting. And I think I needed to come in to kind of correct some things that may be in the public mind now that they've seen that the sleeping gas seemed to have infiltrated through the room when you were talking about 91A. And it got to the point where it appeared in everybody's mind to be an agreement that no minutes had been released for 11 years, which isn't the case at all.
No.
And the other point that, or one of the points that the county attorney was making was that you would somehow have to hire additional staff and get larger databases put together in order to accommodate for this monitoring of the minutes. And for a few years that we did it the way we were supposed to do it, Robin Reed had a pretty good handle on getting the minutes together, reviewing them, presenting them to the commission, and then the commission letting them out. I think the county attorney as well was struggling with, as we all struggle who come out of the private sector, with the idea of how this 91A operates, because it's different from the private sector. And what he was advising you of, it was almost like watching an attorney advising a business owner. And everything that he was saying was correct if you were in the private sector. In the public sector, however, it's different. You don't have, as commissioners, you don't have contracts with builders, suppliers, attorneys, or anyone else. The citizens of Carroll County have those contracts. And the reason for the right to know law, the 91A, is so that we who have those contracts can stay fully informed about how you, our agents, are operating within those contracts or dealing with people in lawsuits. So it's not a simple matter of saying that perhaps a company's name might be besmirched by some negotiating ploy or some disagreement. That's not for you to say. The people who own the contract or the agreement, the citizens, are the ones who make that determination. When a company or an individual does business with a government entity, they give away their right of privacy because they're now contracting with all 40+ thousand people of Carroll County. The only time that there's protection of an individual is that small area of workers' rights where you have to protect the worker's good name, if you will, even though they're a government employee. But if anyone wanted to come in and find out what we're paying anyone at the county for any service or any job done, they can do that. Because that sort of information is public information. So I think I understand the attorney's struggle with this, but I think what happens is that when you come out of the private sector and into the public sector, you really have to have an aha moment where you understand that it's not your business, it's the people's business that you're doing. The last point on that is that one part of this that is not protected at all by 91A is the actions of any of the commissioners. And you can't determine through whatever conversation or whatever negotiation or whatever complaint or whatever issue came up that for some reason a response by a commissioner or a position by a commissioner is somehow protected by 91A. It isn't. There's no protection whatsoever for a commissioner or any elected official. And there's no ability for any elected official to sue for libel. You can say whatever you want about any elected official. It's obvious that or Fox News would be out of business. That you can say anything you want about an elected official and there's nothing they can do about it. Also, that public official's actions can be fully scrutinized. So if any part of what you're doing in your review of the 91A minutes is somehow premised upon the idea that we can't, we want to shelter some elected official or some county official from public scrutiny. That goes against that particular law. So I think I'm still struggling with this idea that something's changed and all of a sudden we're looking at the right to know law in some different way, so we can't release any of the minutes. I have watched occasionally the reasoning for going into public or non-public, and there have been not that many grievances, employee grievances, but a significant number of contractual conversations, legal conversations, and other conversations that I'm just going to continue to beat the drum that I think you need to let some of those minutes come out into the air and have the public see what happened. Thanks.
Well, my comment would be that I agree with you mostly in what you said. However, as commissioners, we also represent the taxpayers in Carroll County, and we need to protect them as well. So when we get into legal matters as to what we release, if we release something that somebody can come back at us for, then that's going to affect the taxpayers, and that's where we come in trying to protect the taxpayers. We are elected officials, and we are elected by the taxpayers. So I agree to some extent with what you said in your comments. On the other hand, I have to also listen to the county attorney as to where he's coming from.
Well,
that said, that's where I stand, I guess.
I think that what you'd find is, first of all, the county attorney is probably not the place you want to get your advice on 91A. But secondly, whatever protections you might want to afford the taxpayers can easily be handled and still comport with 91A. And hiding behind 91A to avoid litigation, I think, is sort of misapplying the law. There's very few cases out there that I've been able to find where a company or an individual has prevailed against a government entity for allowing information to go public. When you go into business with any public entity, you understand that your right to privacy, if you will, or right to contractual privacy is pretty limited. So
I have not seen in the 91A any wording of private versus public as far as what can be released and what can't be released.
No, because everything that...
So it's your interpretation as to
no, it's not an
what the public
interpretation
is.
at all. Everything, the reason you don't see anything in there about private versus public is that every action that's perpetrated or held within this setting is public. There are no private contracts. There are no private.
I agree with that. That's what I said.
So there's
I
no
agree
reason for that law to ever get into the private versus public discussion. Everything's public.
Yeah. Okay. Yes.
And actually, I brought something in reference to minutes and non-public and public. And I have 91A. I had gone to the Selectmen's Institute in '08, and I found this lovely thing about public meetings. And it talks about 91A and the statutory exemptions. It also tells you about meetings. That meeting with Carroll Jowdy was a meeting because you had a quorum of the board. Meetings are supposed to be posted 24 hours. Here's a copy of the laws if you'd like them.
Right.
It also explains the statutory exemptions for keeping non-public minutes. And in fact, I think on your August 3rd meeting, you went into a non-public session and you did not adjourn from your public meeting. So if you're doing those minutes today, you might want to correct that.
Okay.
But I'll give you a copy of this.
Yeah, I think, I guess I need some clarification in regards to the meeting with Carroll Jowdy. I was the contact and I was meeting with her. Therefore, I did not post it because I was the only one that was to meet with her, scheduled to meet with her. What happened was Commissioner Solomon came in early for the posted meeting that followed. Okay, go ahead.
With that, so this was a work session.
This was a work session with me and the landscaper.
Excuse me, of a Board of Commissioners, not some other category of meeting. A work session must be properly noticed and open to the public. It is not a non-public session unless the subject matter of the work section involves one of the exceptions to the public meeting requires listed above. Those are the dismissal, promotion, compensation, the hiring of a public employee, matters that would affect someone's reputation if made public, buying or selling or leasing a property, etc., or consideration of lawsuits threatened in writing or filed against the body of one of its. To go on, minutes must be kept of the work session. Minutes can be brief. There is no requirement to allow public comment at work sessions. After all, the purpose of the work session is usually to do the work of the board, not to discuss issues or take action on them. Now, were there minutes taken of this work session that Commissioner Solomon came and it ended up being a quorum of the board? I'm totally confused. When you have two commissioners present, this occurred at a selectmen's meeting at one time. A commissioner from a precinct was there. One of the selectmen went over to talk to her. I went over to say hi. I was warned. Two of us can't be here. It's a quorum. It's not a posted meeting. I had a phone call the other day to meet with one of our taxpayers. He wanted to meet at 11. I called the town hall. I was informed, you know better, Kathleen. We don't have 24 hours to post this meeting. As elected officials, you have to realize if two of you are there, that presents a quorum. That presents a meeting. And I know you're very busy now with contracts and the nursing home and clocks and furniture and life safety things. And it's hard to get the three of you together. But taxpayers need to know 24 hours in advance when these meetings are, because there are numerous taxpayers here that have a lot of qualities that could assist you and lend a hand. But if they don't know about the meeting, they're not going to attend a meeting. At that meeting with Jowdy, when Commissioner Solomon came in, if this was a meeting with you as a representative of the board, the minute she walked into the room, that presented a quorum of commissioners. That changed the meeting. But that should have been posted 24 hours in advance because it was a public meeting.
Well, if she walked in,
and
after it started, there was no way it could be posted 24 hours in advance. The one that was supposed to be held following that meeting was posted. That's why both of them came to that meeting. That was a posted public meeting.
No, it was not.
A non-public meeting, I'm
so
sorry.
What I'm saying is, I'm not talking about the meeting that was scheduled. I'm talking about your meeting. Commissioner Solomon came in. That constituted a meeting. And if you had a meeting scheduled with this person, Carroll, Jowdy, a lawn person or whatever, that should have been posted on the board in another place. Any public meetings, 24 hours in advance, by the letter of the law.
Okay, we'll take it under advisement.
Yeah, I also want to add something. You said that she came in, and then after that Commissioner Solomon came in, so you were two together. I talked to Carroll Jowdy, and she told me she had a meeting with you. It started at 10. She came a couple minutes late, and when she came, there were two commissioners there. She had a meeting with two commissioners. That is what she told me.
Okay. Mr. Babson.
I think this is a lot to do about nothing. Yes, the law says that it's a meeting. They're running a $23 million business. They can't be, there just isn't enough time with what's going on here to do it absolutely perfect. There's been a huge change in the way this commission has been run in the last 4 years to their benefit. I think the proper thing to do was have David have her come up here at a meeting of the commissioners, but perhaps there wasn't time. And you know, if you run a business, you understand that you can't do everything perfectly. And I think they've done a very good job. What time was the non-public session posted for?